What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? We're back at it today with another video on the Sarah Boone case. It's been really interesting to see how her and her lawyers, multiple lawyers, relationships have kind of progressed and how those issues have caused a lot of delay in her case and potentially brought up some appellate issues. Well, we have another handwritten letter to Mr. Bankowitz, Sarah Boone's lawyer, and copied the judge, Judge Wooten, on the case with the issues she's having, the questions she's having. And we're going to go through that entire letter today and talk about what's legitimate, what's not, and what could potentially be an appellate issue. If you've enjoyed the coverage of this case, hit that like button and let me know. Make sure you subscribe, because if we get to 200,000 subscribers before this trial starts, I am going to go over there, sit in that courtroom for a day or two, take a look at the juries, take a look at Sarah Boone and her lawyer, see if we can look at that relationship and if we get any difference being in person than just watching the live stream, which we'll do a lot of that together as well with the normal recaps and breaking down what's going on in that courtroom. So make sure you do all those things and comment below, because this is not live. It is a premiere. Comment below with any questions you have or comments you have about this letter and about this case. But without further ado, let's get to the letter itself. And we've got, I believe it's 5 pages of it. We'll see if I can get lucky and start with page 1 and work our way down. Yes, here we go. Page 1, it may be blurry, but don't worry. I'm going to read the letter in its entirety. This is from January 10th. So it's been almost 2 weeks since she wrote this letter. The first time I saw it was just a day or two ago. So she is writing to Mr. Bankowitz. Hello. This is before her pretrial on January 17th, where we know she wasn't there. He wasn't there because he had COVID, and they did not meet after the earlier pretrial where the judge said they had to meet, but he got COVID and they couldn't meet, and they have a new defense, even though they haven't met, which is very weird. And the trials continued to April. Hello and Happy New Year. I hope the holidays were lovely and very memorable for you and your family. I just wanted to check in, as I have not heard from you since the status hearing back on 12/27/22, and want to confirm you are still my attorney after your motion to withdraw was filed on 12/19. It is my understanding that you are, which is why I am writing to you directly, but also including Judge Wooten, for fear I do not receive a response like the last almost 5 months, 21 weeks, 147 days. It is very important to me that you are aware of my questions and concerns for the anticipated pretrial conference on 1/17/23. We don't even know if he received this letter prior. If you are unable to speak to me beforehand, which I am very much hoping you will be, unfortunately, I am unsure what else to inquire about, as I am unaware of any other progress going on in my case. So she's saying, I have questions, but these are only questions I have based on what I know. And there's a ton I don't know about this case because you haven't kept me up to speed. In the meantime, please see below, and thank you in advance for the information and clarification. Number 1, pretrial conference Tuesday, 1/17/23. I would like to be in attendance. What time, please? We know she wasn't there. I have not received a notice via mail or heard from you to ask, and no time was stated during the status hearing. Please make the necessary arrangements for me to be included. It is my right. I have a problem that she wasn't there. It is her right to be there. It's her case. Why wasn't she there? And if the judge is getting these letters, I don't know why the judge wouldn't make sure that she was there if the lawyer is obviously not doing that job. I don't care if he filed a waiver of appearance. She has made it clear in multiple letters, and she'll make it even clearer later in another paragraph, that she did not sign that waiver of appearance, and she does not consent to waiving her appearance, which to me is problematic that she's not there. All right, page 2, paragraph 2. Waiver of appearance. Please mail or bring the appropriate documents for me to unwaive my appearance going forward to everything. And again, she wrote this before January 17th. I am able to be included on, so I am kept updated with any and all status of my case. It is my right. Please note, I have not signed any paperwork for you since the start of your representation. That's scary if he's filing notices like waiver of appearance. He is then waiving her rights for her without her agreeing to them. As my attorney, so I am unclear how my right to appear was waived in the first place, nor have I verbally given permission for the waiver of either. Please provide the signed copy at your earliest convenience. Reason for withdrawal. It was not made known to me by you as my attorney or stated by the judge to the court during the status hearing. I was completely blindsided and still massively confused for the attempt, as our attorney-client relationship hasn't even been established from the 2 hours we have spoken, out of now 4,536 hours, she means, and the general information it was when we actually did. If you had genuine, legitimate concerns, I thought from a professional, real, moralistic standpoint, you would have discussed with me, or at least mentioned, rather than be uncommunicative for almost 6 months, an entire half of another year, for me just sitting here with nothing to show but the perpetual question mark still over my head. I would have hoped if you were unable to maintain your workload, which still presently includes me as your client, that's a good point by her, you would have not made the decision to take the case and even given me the selling points on all of your capabilities and resources. I buy it. A lot of lawyers, myself included, clients will have questions about our experience, our education, our results, what we think we can do, our capabilities. So he was selling her on his capabilities for 2 hours before deciding to take the case. And just a few months later, now his caseload's too heavy? I don't get that. Why? Please help me understand. We are supposed to be working together and for each other rather than against. It worries me futuristically. Also, I have not to date received the copy of your withdrawal. Judge Wooten said I was included on when reading the certificate of service during the hearing. Please provide me a copy. Absolutely nothing she has said so far is unreasonable or problematic to me, regardless of any of our feelings about her interrogations or what she may or may not have done or how she may or may not have answered certain questions. Number 4, phone account. It was previously told to me by you in our one in-person meeting on 8/22/22 that you already had this set up and were having your assistant look into it so we could use. After not answering any of my calls, the few times I did make an attempt to touch base with you to provide requested information you asked me for, I stopped calling you, Mr. Bankowitz, and have not to date since September of 2022. I kept hoping you would call me or set up a visit, even for 15 minutes, which has not happened. Please help me understand why you gave me your personal cell phone number. Again, not making sense to me. I'm not understanding what this conflict is he has with his family and stuff like that. It didn't seem to be a workload conflict. Also, to clarify for you, the judge, etc., I did not avidly search for the statements regarding your public reprimands in 2015 and 2018. She said, I just want to make sure everybody knows. I didn't go searching for these reprimands. In an attempt to speak with you, once I had no response to my letters or calls, when having someone, meaning someone else on her behalf, looked up Mr. Bankowitz for any contact alternative and to confirm your address from a letter I sent you that was returned and then resent. So she's trying to get a hold of him, trying to send letters. The address isn't working, so she asked somebody on the outside to take a look for her. The reprimands were then discovered. And for the same complaints as mine, lack of communication. So, does she know that? And is she trying to use that now, saying, I have this lawyer who constantly does this, ineffective assistance of counsel? Is she really just trying to put the pressure on him to get him to respond? I think there could be multiple uses for this letter that she's writing, and it's a pretty smart letter because if I'm Bankowitz, I mean, obviously I'm hopefully never going to get in this situation, but first off, call clients back. Second off, if they mention your reprimands for doing the same thing, maybe it'll put more pressure on you to call them back. And if you still don't, if I'm an appellate court we're building a pretty decent case for ineffective assistance of counsel, and that, frankly, her constitutional right to counsel may have been violated just by the lack of communication in this case. During the status hearing, when I made this known, I was not clear in the end if you were going to actually set up again the phone account to be used, which any and all callers, inmates, must have established in order to speak to family, friends, attorneys, anyone. It is nothing new or extra from all the costs that were incurred that can be submitted for payment to the court as you have done in the past already. This is how attorneys communicate with their clients here in OCCD. Another opinion, in addition to the 45-minute video visits, 15-minute at-home visits, in-person visits, and of course, the Postal Service. It would definitely make sense to use in avoidance of even more time being exhausted in the length between any visits in the future, which will only help the progress of everything. Will you be utilizing? Final page here. Actually, 2 more pages. 5, discovery/case materials. In the status hearing, you stated you have 2 boxes of information that are out of order and unorganized. Have you organized and reviewed? How long have they been in your possession? When will we be going over them? All very fair questions, and he better organize them and read through them. That is literally his job. He's getting paid for that. He signed up for this to be appointed in these cases. So she's not asking too much. I wish you could hear some of the things my clients ask me for, right? And we do it. We order things. We order records, medical records, bills. We look through them. We fight if the bills are wrong with the medical providers. We talk to them if they've screwed up and put the wrong person's name in a medical record. You have to review these things as a lawyer. That's a big part of our job, reviewing documents and finding out what's in them, what's good, what's bad, what's wrong, what's ugly. It is extremely concerning that this is all you have. It has been said that there were 3, 5, 6, a ton from some of the other attorneys prior on my case. And I do feel bad for her in this situation. And this is why we have this channel. People don't understand what their rights are. And attorneys are telling her things, and she doesn't know who to believe. Is it 2 boxes? Is it 6 boxes? I've had 2 officers of the court that were supposed to represent my interests that are telling me different things. Is she difficult? Maybe. Is she annoying? Maybe. Is she lying? Maybe. But if it's true, I do feel bad for her. And anyone in this situation that just is getting lost in our judicial system and people don't seem to care about them when it is your job as a criminal defense. Now, every one of you out there that didn't decide to be a criminal defense attorney, and this is not your job, you didn't swear an oath, you're not an officer of the court, I understand if you feel differently. But if you are a criminal defense attorney accepting court-appointed cases, and you get appointed this case, it is literally your duty and job to make sure this doesn't happen. Which is it, and what is there? Fair question. 3 years later, I'm still wondering. I have also put in numerous hours, pages, pen ink of my own information, which I'm praying is either in one of the boxes you currently have. Please let me know. As the aided amount, I can't read that word, of even more time to locate, receive, review anything missing from everyone receiving before then withdrawing. Will most definitely be extremes. That was kind of a weird sense. I think she means like, I need to know because it's going through all these different lawyers, people telling me different things. I need to know what you have. I don't know what you have. I also could assist in organizing what you do have, considering it's all part of my case. She's right. And a lot of times criminal defendants help a lot with that. I am eagerly waiting and more than willing to help with this and everything else. I just need to see what there is, which I have not yet 3 years later. Number 6, the prosecutor. Is there a new one on my case? I noticed his attendance during the 3 status hearing attempts and came to the conclusion that there is. Since you have not communicated with me, this is new information, nor any announcement made with the court. I do not know. If so, what is his name? What is his background? Fair question. Who are we going up against? What's their background? What's their experience? Have you ever had a case against them? Are they going to be aggressive if I take the stand in cross-examination? Or are they a little easier? This all goes to trial strategy. She's more than entitled to this information. Mr. Bankowitz, you must understand how insignificant I have been made to feel with the never-ending debacles, hurdles, and stumbling blocks I have and am going through and still facing since becoming incarcerated. No one seems to listen ever. I refuse, absolutely refuse to believe this, my entire experience to date, really is how our justice system operates. I refuse because, as said to you, Judge Wooten, now we'll get to the last page. We are almost done here. Court, everyone else in the status hearing, and to anyone who truly cares, my reason is hope, never ending, no matter what, hope. This being the entire reason I am even here for my incarceration. Nothing is impossible with God, and I await my day to say my truth inside of everything. Please don't give up. I have not and will not ever. I await your response. As always, Mr. Bankowitz. Thank you sincerely, Sarah Boone. So this is not the way our justice system is supposed to work. I don't care if it's a public defender or court-appointed lawyer. You guys have heard public defenders on this channel. You've seen public defenders on other channels. I've told you what public defenders say. I've worked with public defenders against them and helped them with stuff. Some of my buddies that are public defenders. And this is not how it's supposed to be. And they would agree with that. If you're overworked to the fact that you can't talk to a client whose trial is coming up for 6 months, that's just not possible. That's not how it works. You need other help. They need a different attorney, whatever it may be. You need to tell the judge you can't handle it. Not that there are irreconcilable differences or anything like that that may be vague and not let you off the case. So I see major issues here. I also see the language in her writing is absolutely going to go towards an appeal. Ineffective assistance of counsel. They weren't able to prepare the case. If she has this new defense, why haven't they been preparing it over the last couple years? Now, a delay and a continuance can help a lot of these issues, because now if Bankowitz preps the case and talks to her a bunch over the next 3 months, then that could change. But my guess is hopefully he's prepping for his February trial. So he's probably not going to talk to Sarah Boone a ton in January, especially with COVID and a backed up caseload. Then in February for 3 weeks, he's going to be trying a capital case. So at the very earliest, he's going to be able to start working on her cases March. So that leaves him 1 month to prepare for a second-degree murder trial on someone that he hasn't even talked to very much over the year-ish he's been representing her. I see major issues in this case. Let me know what you guys think. I know you're probably going to be harder on Sarah Boone than I've been in these videos. Listen, go back and watch the interrogation and the body cam footage to see about what I think about how she describes the situation. But as it sits right now, any criminal defendant, anybody in any case in our justice system, civil or criminal, I just hope they get better lawyering than this. And I hope that by watching videos like these and other videos, they know what to expect from a lawyer, so they'd be able to have what they need to go in there and the tools to describe this to the judge and tell them this is not right. This is not how it's supposed to be, which Sarah Boone seems to be advocating for herself. So I do give her credit for that. Hopefully you guys enjoyed this video. If you did, hit that like button and make sure you get in the comments and let me know what questions you have about this case. And if you want to see continued coverage of this case, tell your friends to subscribe as well. Thanks for joining me. I'm out of here.